Greetings, Twitter, X. Good evening. Once again, I'm here live, and I wanted to talk to you guys. My original plan, I've been wanting to go live, and I was planning to go live tonight, but my original plan was to discuss the abortion lawsuit. The case went before the Supreme Court of Texas for the preliminary injunction. As you remember, on that one, Zarowski versus Texas, the district court had issued the preliminary injunction, and the Texas State Attorney General appealed it to the Supreme Court of Texas, and they automatically issued a stay, and they heard the arguments day before yesterday, on Tuesday, I believe it was. And I was going to talk about that tonight, because I found it interesting. I actually had a chance to watch the hearing, and I actually linked the hearing to my Twitter feed, my X feed, so that anybody who wanted to watch the video of the hearing, they could do that. I actually posted it queued up already to that hearing, because there was two hearings. That one was the second one, and I wanted to talk about that because there was details that I wanted to really get into. However, yesterday as I was reviewing and reading and stuff, and I received the alert about the border buoy case that Texas sued the U.S. for an injunction, because the U.S. had been tearing apart the Concertina wire to allow immigrants to come in and whatnot, and Texas had sued and was requesting a preliminary or permanent injunction so that the U.S. could not tamper with or destroy the Concertina wire. And that particular lawsuit, there was a ruling issued saying that Texas was they were going to deny the preliminary injunction against Texas altogether. And I was reading into that yesterday afternoon, and through the course of this morning, I tried to read into it a little bit so that I could talk. I wanted to talk about that after I talked about the abortion hearing. But as I was getting ready to go live earlier, there was another ruling issued, or opinion issued, from the United States Fifth Circuit Court of Appeals on the border buoys, and I actually have downloaded and I printed the appeals opinion, where the three-panel board of judges ruled and basically said, okay, the state of Texas has to move the border buoys and the Concertina wire out of the river and onto the riverbank. Basically, what they were told to do. I don't know why they didn't say go out and remove it, but I guess it's because since this is a preliminary hearing appeal, that it still has to be, the actual case has to be heard at the district level again on the merits. So I'm thinking that's one of the reasons why. But earlier the Fifth Circuit issued their opinion saying, okay, Texas, you got to move that stuff. And I was like, wow, because that's two rulings on the same subject against the state of Texas. And it's what's worse, it's two federal rulings against Texas. And so I decided that I was going to talk about today's ruling and kind of talk a little bit about the ruling from yesterday, because I found it a little more interesting, and the fact that there's it's a domino effect, and it's basically like Texas is kind of trying to stay afloat in a sinking ship. And I don't see how they're going to get out of this, to be totally honest with you, and I'll explain why in just a minute. But there was several factors in the ruling that led me to believe that Texas will find it next to impossible to win on an appeal. And so I want to go through those real quick, if I can. The first one has to do with the fact, and if you read on the very first page of the opinion, it says that the United States filed a civil enforcement action against Texas, alleging that the installment of the barrier violated the Rivers and Harbors Act, and I have it highlighted here, Rivers and Harbors Act, which of 1899, which is called the RHA. Now, I want us to look at Section 10 of it, because that's the section that's been the crux of the center of this lawsuit, and I wanted to look at that real quick. I'm going to pull it up. This is it here, and I'm going to go to full screen here. Give me 1 second. I'm going to try to go to full screen here and pull it up. And we're going to read this real quick, okay? It says, the creation of any obstruction not affirmatively authorized by Congress to the navigable capacity of any of the waters of the United States is prohibited. Okay, looking at that, the argument that Texas is making in this sense is that they're talking about whether or not the Rio Grande is considered navigable waters. Now, number one, the jurisdiction and the determination of that is made by the Army Corps of Engineers, I believe, if I'm not mistaken. So they've already, in a written document, expressed that it is considered navigable waters. So that issue is established. Now, here's where I think the crux of the argument against the United States, this is where I think, against Texas, this is where I think Texas is not going to be able to succeed, number one. If we read this again, and I'm going to go back to the full screen, it says, the creation of any obstruction not affirmatively authorized by Congress to the navigable capacity of any of the waters of the United States. Okay? So it's saying obstruction of any of the waters of the United States is prohibited. So here it's not specifying in totality the navigable capacity. It's saying the creation of any obstruction in any of the waters of the United States is prohibited. Okay? So that's important to know. That tells me there that, because basically in this section 10 of the RHA, it comes down to Texas is in violation of it in two ways. First way is what I just read. The second one is, if we look at the rest of it, it says, and we at the bottom it says except on of the United States, except on plans recommended by the Chief of Engineers and authorized by the Secretary of the Army. In other words, permission. And if we read the bottom sentence there, it says the second clause prohibits the construction of specified structures in those navigable waters absent permission from the Corps of Engineers. So in other words, Texas should have, regardless of whether it's navigable waters or not, should have requested permission from the U.S. Hold on, give me 1 second here. I screwed up. I'm going to pull this up again. I'm trying to get my main screen here. Okay, there we go. Sorry about that. Okay, so basically, the second factor is that Texas should have asked for permission. They did not. So, and that's the second factor of what's going on. And I'm trying to load something here, and it's not agreeing with me, so bear with me. Okay, got it. Okay, so that's one thing right there. Now, the second factor that I think is going to really hurt the state of Texas is if we go to page 26. And this is going to be interesting when you see it. I'm going to pull it on the screen and then zoom in. And this is it. It says, the district court, in finding that the public interest favored the United States, the U.S., emphasized Supreme Court decisions. What decision do you think that they emphasized? Okay. Hint, hint. When this lawsuit first came about, one of the first things that I said was that that Texas was going to have a hard time winning this or successfully defending themselves in these lawsuits because of the fact that there is existing precedent. And I referred to a specific case, which was Arizona versus Texas, or versus the United States, my bad. Arizona versus the United States. And that was in 2011, 2012, when they were disputing whether or not Arizona had the right to enact and enforce SB 1070. Well, if we look at the bottom sentence of this specific paragraph, it says, more pointedly, in Arizona versus the United States, 567 in 2012, the Supreme Court noted while Arizona may have understandable frustrations with the problems caused by illegal immigration, as Texas has alleged, because Texas is saying the same thing here, the state may not pursue policies that undermine federal law. So basically, what we got going on here is that these three justices in the Fifth Circuit are saying Arizona had the same immigration issues. They were frustrated, but that does not give them the right to undermine or to enforce immigration law. So these justices are applying the precedent of Arizona versus United States. That's the second factor that is going to complicate these lawsuits for the state of Texas. And if we read, and I have it here, give me 1 second. I don't have the screen for it, but let me look it up here. And that's in the next paragraph, or the bottom sentence of that paragraph. It says, and this is my third factor. It says, further, the district court emphasized that the balance of priorities Congress struck in the RHA and the Rivers and Harbors Act outweighed Texas' asserted interests. Okay? Courts may look at the statute at issue for guidance concerning whether the issuance of a preliminary injunction would be in the public interest. Okay? And he says here, to the bottom, he says, Congress has spoken to the public interest through passage of the RHA, and the Supreme Court has emphasized the same. We are dealing here with the sovereign powers of the Union, the nation's right, that its waterways be utilized for the interest of the commerce of the whole country. So in other words, basically it's what we call a supremacy clause issue. So, meaning that the federal government, and pardon me for using the pun, the federal government's interest trumps states' claims or states' interests. In other words, it overrules it, it overpowers it, it supersedes it, basically. So that's what we're looking at right here, is the fact that the federal government is going to supersede the state at all costs, and that's more kind of what happened with the lawsuit yesterday. Because, as I said, the one yesterday, Texas had sued the U.S. for and requesting a preliminary injunction so that the U.S. could not destroy or tamper with the Concertina wire or the border buoys at the border. And in that case, the judges, the appeals judges said, not so fast. We cannot give you the preliminary injunction because you don't stand to you don't stand to win on the merits. And there was other stuff in there, and I don't have the copy of that ruling in front of me. I didn't have a chance to get it. But basically, they said not so fast. So now you've got two rulings on the same subject against the state of Texas. The way I see it is this. In part, one of these rulings is going to be precedent on the other. Whether the state of Texas wants that or not. One of these rulings is going to act as a precedent against the other one. On top of that, you've got the precedent of Arizona versus the United States, which clearly the appeals court sided with it. So you got precedent on top of precedent. You got the fact that the interests of the U.S. will outweigh the interests of Texas. And even in this ruling here with the Fifth Circuit, they even went as far as to say that Texas claims that they're being invaded, but that's not necessarily the case. So, I mean, they cut Texas' arguments down completely in this ruling, and they quoted a lot of statutes, a lot of history to affirm what their decision is. And it's going to be up to Texas to build a case that refutes all of these statutes, all of these court cases, all of these historical elements that, number one, the U.S. is employed in their arguments, and that the appeals court referred to in their opinion. So it is going to be really difficult, if not impossible, for Texas to win this. I mean, I would be surprised. I am actually anxiously awaiting to see what the actual appeal is going to look like, because I'm interested in seeing what Texas's argument is going to be against the judges. And it's going to be interesting to see how this plays out and do a comparison as to what their appeals argument is, what the statutes say, what the courts have said, and seeing, how it all goes with or against each other. It's going to be interesting to see. I mean, it's just, we're going to have to wait and find out, because, I mean, it's going to take them a little bit of time to do the appeals. And it's going to be hard to see, how they're going to approach this, because you got to file two appeals, and both your cases are stacked against you. One can affect the other, so it's going to be very interesting to see the end result. Well, that's all I had for tonight. I will probably not get back online tonight for the court case for the Supreme Court, Texas Supreme Court. I'm gonna prepare it right now, but if I can, I will come back live later on. If not, it'll be sometime tomorrow during the course of the day when I will go live, and I'll talk about that, and I will probably go back and forth using the video for reference. If you want to watch it, I do have it linked on my Twitter feed. You can watch the hearing. It's about an hour long, and it's very interesting. And when I do go over and do my analysis, you'll see things that I'm going to point out that are going to be kind of interesting in that respect. So, side note, before I go off the air here, as it were, I mentioned a while back, I think on my Twitter, that I had gotten blocked by the State Attorney General on X, on Twitter, on his personal feed. And I didn't let it faze me. I didn't worry about it, because honestly, most everything that I post on X is I look at lawsuits, and I look at events, and I post my perspective as far as what I think, whether or not the state has because I'm very critical of my state of Texas, to be totally honest with you, and I try to analyze and give my layman's perspective as to what I think is going to be the end result, or what I think should be the correct or not correct thing. And I've never tried to be offensive. I think I mentioned that in my tweets, with the exception of the one tweet that I thought caused me to get blocked, which was 3 little words. I'm not going to even mention it. But suffice it to say, I was blocked, and I was like, okay, no big deal. I mean, I think I posted maybe once or twice to his business Twitter feed at Texas AG, in reference to some court cases. More specifically, I think the last one that I did was the case from yesterday, where he mentioned he was going to appeal it, and I was like, okay, well, you're going to appeal it. This is what I think. This is what I believe is the deficiencies. This is what I think is going to be your difficulty in winning the case. I think that was the approach that I took. But when I got on my Twitter X feed yesterday, I was surprised to see that I actually saw a tweet from his personal Twitter feed. I was like, okay, so I think I'm unblocked. So I went and I checked, and by chance, I am unblocked. So I don't know if that was just temporary. If it was, well, that's fine. Or if he had a change of heart. I mean, if he did, I thank him for it because, as I said, my intentions were never to be offensive, but to be constructive and be, give a layman's perspective. See, the thing is this. This is the way I see it. I'm going to be as brief as I can about it. Is that our environment politically today is so charged up that there's not really anybody that is, at least that I have seen. It's rare to see somebody who will put an objective comment or an objective perspective on social media. Everything is either you're conservative or you're liberal. You're Republican or you're Democrat. You're with the GOP. You're not with the GOP. But in my case, because I've seen that it is so politically charged, I decided to remain impartial and nonpartisan, and try to be as objective as I can, in my comments, as far as like with lawsuits. And I've dedicated a little bit of my time analyzing certain lawsuits because, number one, I find them interesting. Number two, you could obviously tell when it's a political fight, how lopsided some of these lawsuits, in all honesty, are. And, for instance, this particular lawsuit that we're talking about tonight, the fact of the matter that, number one, when you're fighting state versus federal will always supersede state. Number one. Number two, when you've got clear-cut precedents that prove your case, to try to dispute it is can be next to impossible. So basically, I analyzed the rulings. I'm like, okay, well, this is what I see. This is what I see. I don't think Texas can come out of this totally smelling like a rose. It would be difficult, if not next to impossible. And I try to give my layman's opinion. So, that's what I do. I try to be as impartial as possible. But now that I actually am able to see his posts and understand more, I can try to be I'm going to try to be as objective as I can going forward, so that I don't offend anybody in that respect. I may post a comment or two, like I did not too long ago. I did get a little religious with the new Speaker of the House, but that is because in my conscience, I chose to direct those words to him, and not being political or being but being more on the humanity side, on the religious aspect of it. Because if he is truly a religious individual, then he needs to go by his biblical, spiritual, religious convictions, number one, in addition to, because the thing is this, everything's so politically charged that it's not an issue of choosing the political side nowadays. It's more choosing what is morally right, what is socially right, what is spiritually right, what is ethically right, because you can't really go by political spectrums anymore, and unfortunately, because of how everything's so charged up. But I'm going to leave that for another day, okay, another occasion, because I don't want to get into all that right now. I just suffice it to say, in passing, I've been unblocked, and I am kind of happy about that in a sense because I know that I kept thinking that maybe I had said something I did, wrong, and maybe I did insinuate something, but my intentions, as I said, have always been to be objective, and that's what I'm going to try to continue to do going forward. Well, thank you very much. Have a good evening. If I can, I may come back live tonight, if not tomorrow. We'll talk about the Texas Supreme Court on the next live stream.